Morning. Thank you for joining us and tuning in. I'm Chris Sexton, and it's my responsibility to deliver lease advisory services from Vickery Holman to our clients throughout our 4 offices in the southwest. Today, we'd like to talk to you about one aspect of that, lease renewals. With all the recent uncertainty, keeping tenants and maximising market rents has become even more important for property owners. But the significance and trend towards lease renewals was already increasing before then with the shift to shorter leases. And certainly in my working career, I've seen a big shift away from rent reviews to lease renewals in terms of the work that we deal with. What we're going to do is talk to you about the importance of being thoroughly prepared, the process, and some of the potential pitfalls and current issues that we're experiencing in the market, and also why it's essential that property owners work closely with advisors who have the knowledge and expertise to deliver the right result. So 2 of my colleagues, Jordan Kennedy, our expert in Truro, and Amy Durkin, our expert in Bristol, are going to talk you through everything that you need to know. And afterwards, we'll take some questions. So Jordan and Amy, over to you.
Thank you, Chris. So before we go through the lease renewal process in more detail, we'd like to begin by letting you know what Vickery Holman can do for you when it comes to lease renewals. Our team are based across the southwest, with offices in Bristol, Exeter, Plymouth and Truro. We have lease advisory consultants based in all of our offices, and we are all experts within our own areas. This means we have an in-depth knowledge of rental values in our regions and can therefore advise you on the level of rent you should expect to achieve and how best to achieve it. We also offer expert advice on other matters, such as the terms of a new lease and important timings in the lease renewal process. We can guide you through the minefield of contracts and terms, explaining the finer details of leases and ensuring important deadlines are not missed. This can help you to avoid problems further down the line in the process of negotiating a new lease and ultimately help you to achieve a positive outcome and the best rent for your property. We have extensive negotiation and arbitration skills, and put simply, our knowledge and expertise can save you time, money, and potentially a great deal of stress. We can help to ensure your property is let at the best rent and on the very best terms. So what exactly is a lease renewal? Essentially, it is a new lease agreement entered into between a landlord and tenant at a legal instant in time after the expiry of the original term of a lease. When thinking about how to deal with an upcoming lease renewal, it is important to establish if the lease in question is inside or outside the Landlord and Tenant Act of 1954, as the process differs slightly in each case. You'll find that most leases do fall within the 1954 Act, and therefore, when most leases come to an end, the tenant is protected by law. To gain protection under the Act, there must be a business tenancy with 6 basic elements. These are: there must be a tenancy, the premises must be used for a business, the tenant must occupy at least part of the premises and must have done so for at least 6 months, the tenancy must not be an exempted or excluded tenancy, such as a tenancy at will or a service tenancy, and finally, there must be a competent landlord. Where a business tenancy is inside the 1954 Act, the tenant has the legal right to renew at the end of their lease. Furthermore, a business lease which is inside the Act does not terminate with the effluxion of time. This means the tenant is entitled to continue holding over, meaning that they can remain in possession of the premises, paying an interim rent, until either the landlord or tenant serves notice to terminate or to enter into a new lease in accordance with the provisions of the Act. If the landlord does want to terminate a lease protected by the Act, there are only 7 grounds on which they can do so. These are known as grounds A to G and are as follows. A, the landlord must show the tenant has breached a repairing covenant. B, the landlord must show the tenant has persistently delayed paying their rent. C, the landlord must show the tenant has breached other substantial obligations. D, the landlord must offer to provide alternative accommodation to the tenant on reasonable market terms. E, the landlord must show that they could let the whole premises for more than the individual parts. F, the landlord must show that they wish to demolish or reconstruct the premises. And finally, G, the landlord intends to occupy the premises with their own business. If the landlord is successful in ending the lease and agrees to on grounds E, F or G, they must pay compensation to the tenant based on the rateable value of the property. On the other hand, if the parties have agreed to exclude the lease from the provisions of the 1954 Act, you will know simply by reading it, as the lease will clearly state that it is outside the provisions of sections 24 to 28 of Part 2 of the Act. If a lease is outside the Act, the tenant will have far less security. They do not have the right to renew their tenancy, and the tenancy will end with the effluxion of time. The tenant therefore does not have the right to remain in possession of the property when the lease has expired. Whether a tenancy is inside or outside the 1954 Act, there is a lease renewal process to follow. It is good to bear in mind that renewal negotiations are often a more delicate process than rent review negotiations, as the tenant has no obligation to stay, and both the rent and lease terms can be reviewed at this stage. The lease renewal triggers a negotiation of what the rent and new lease terms should be to reflect market conditions at that time. The benefit of instructing the Lease Advisory team at Vickery Holman is that we will conduct extensive research to provide an informed opinion of market rent, and we can offer expert advice on the terms which must be negotiated in the lease renewal process. These can include, but are by no means limited to, the length of the term of the tenancy, whether or not a break clause is to be included, and if it will benefit the landlord only, tenant only, or if it will be mutual. If there is to be a rent review, and if so, will it be based upon the open market rent at predetermined intervals, or will it be indexed? What the repairing obligations of the parties will be, whether or not the lease can be assigned or sublet, and on what grounds, and of course, whether or not the lease will be inside or outside the 1954 Act. Whether a tenancy is inside or outside the 1954 Act, we will read the lease and prepare a lease summary. We inspect the property. We research, verify, and analyse comparable market evidence to determine market rent. We will then report our findings to you and our recommendations as to the best new lease terms and the rent that you can expect to achieve. And then with your agreement, we will begin negotiations with the tenant and see these through to conclusion. Our goal will always be to finalise lease renewal terms by mutual agreement without going to third party. This is preferable and more often than not achievable. And then when agreement is reached, we will prepare heads of terms and send them on to your solicitor.
Thank you, Jordan. Moving on to important timings. As Jordan mentioned earlier, we've got two notices here. The Section 25 notice served by a landlord to a tenant, and this is either to initiate a new lease or to oppose a new lease. Additionally, we have the 26 notice, which is served from a tenant to a landlord. If you have a lease that's inside the Act and want to renew, a service of a Section 25 notice is usually the done thing. The timings are important here, and the notice must not be served more than 12 months and less than 6 months from the date you want the tenancy to end. This is either the actual lease expiry date or a date after this if that date has already passed. If there is an inside the Act lease and you don't want to renew, as Jordan said earlier, a Section 25 notice must still be served, but this time opposing a new lease and offering one of the grounds A to G as a reason why the lease cannot be renewed. Equally, if you are in receipt of a Section 26 notice and do not wish to renew, then a response must be given to the tenant within 2 months to this notice, also specifying one of the grounds A to G. An outside the Act lease is easier for the landlord in that the tenant must usually leave on the date of the lease expiry. and there are no strict timescales. However, we would suggest if you wanted your tenant to stay, it's important to begin negotiations early. This gives you the best chance of agreeing new terms in a prompt manner. And also, if the tenant shows signs of not wishing to stay on, then you have longer to market your property for a new letting. So we recommend that a surveyor is appointed about 12 to 18 months before the end of the tenancy. If you have an outside the Act lease and don't wish to renew, then landlord can serve a notice to quit according to common law. There are also some specific lease terms in some leases to be aware of. The important thing with an outside the Act lease where you don't want to renew here is the acceptance of rent or other monies. It should be rent should not be accepted here, because it can often lead to a tenancy that becomes inside the Act, and therefore your tenant will automatically be given the right to renew. Another issue here related to timings is the minimum energy efficiency standards, which came into force in April 2018. This states that a property must have an EPC, and it must have a rating of higher, or A to E, rather than F or G, in order to be let. So we need to leave enough time here, one, to check that the property has an EPC, to check that the rating is okay. If it either doesn't have an EPC or has an expired one, that a new one can be commissioned. And also to allow some thought, if the rating does come to F or G, what kind of works would be required and the timings there to get that up to standard, so a new lease can be prepared. I also wanted to touch briefly on the role of solicitor, obviously a hugely important factor in a lease renewal. Solicitors will be able to offer advice on most issues regarding commercial leases, but particularly in relation to the work we do, the drafting of new leases, often in response to heads of terms that we have provided for them. The service and responding to notices, such as serving the Section 25 or responding to the Section 26, and also handling applications to court in the event of needing a third-party determination via the courts. We've got a couple of current issues here that we've identified in the last sort of 12 months, obviously been a strange couple of months. The first one here is really rise of Section 26 notices following disruption caused by the pandemic. This is most likely tenants taking advantage of what they perceive as a falling market, and is in many cases. And for the first time in a long while, it's been common for landlords to receive Section 26 notices, pushing for new leases. The rents often proposed are much lower than passing, particularly in the retail sector. So landlords need to be ready to react to these notices. Equally, thinking about whilst the market is uncertain, can be tempting for landlords to allow tenancies to hold over until circumstances improve. But if the lease is outside the 1954 Act, as we've mentioned before, this inaction can hand the tenant protection by default. This can be tricky for a landlord, and there is a possibility of granting a tenancy at will, but this would only really be handy if the landlord can show current negotiations with the tenant to agree new lease terms. So we would recommend that landlords need to identify outside the Act leases and prepare to renew these kind of earlier than ever. Another trend that we have seen recently is the emergence of reversionary day one rent review leases, and the rent review here would be upward or downwards. This type of lease has appeared so that the tenant will commit early to renewing a lease on the day after their current lease expires, and they do this on the promise that on day one of the new lease there'll be an upward or downward rent review. The benefit for the landlord here is that they can secure a tenant for a new term in a fairly unsecure market in places. And for the tenant, it provides that they're not signing up to paying more than the market rent. And also it gives the time for the market to settle before the rent is assessed, something that I think is useful at the moment. Finally, we've also seen attempts of tenants trying to change the demise of a property at lease renewal. Example of this is if there's upper floors that are residential and part of the lease, or something like a separately accessed office, where they're viewed not as a benefit but more of a hindrance to the tenant. We've seen some national retailers that are becoming keen to offload anything that isn't their direct operational space. It's important for landlords to remember that the protection of the Act only applies for the unchanged demise. So the tenant can't insist on changing this, or they lose the right to renew a new lease. From the landlord's point of view, there's good reasons for not allowing this, such as the property then turning into a multi-occupational building, need for service charge, things like that. And also a landlord is likely to want to retain the certainty of a single tenant, avoid the risk of vacant space. So a couple of kind of modern issues we've seen there. I'm also going to take you through a very brief market update of the three main sectors. This information is for the Southwest region over the last 5 years. So we'll have a look at retail first. The black line there is the average of all leases, but the other lines showing quite a mixed response there. Generally, retail rents have been falling, and that certainly shows through from 19 to 20. There is a big jump up into 21, which might be quite a positive thing, but equally that some of the data might be a little skewed there. Interestingly, we've got an average lease length of 7 years and 5 months, and average time of rent review there is 4 years, and average time to lease break 3 years and 8 months. It's still looking relatively long leases, but we suspect that leases will become ever shorter, probably around the 3 or 5 year mark as going forward. With office data there, as is expected, it's fairly flat level office really. Nothing much has changed. There are a few changes there in the individual lease lengths there. Average lease length again, 5 years and 10 months. Average time to rent review slightly less here at 3 years and 7 months, and average time to break 3 years and 2 months. So kind of similar figures there. And then in industrial, is sort of the winner among all the sectors at the moment with the increasing rents. And also similar lease terms here, average length 7 years and 4 months. Similar times to rent review here, just under 4 years, and also lease break. So still seeing some 10, 15 year even leases being signed for industrial at generally increasing rents sort of across the board. At this stage, I'd like to bring on two of my colleagues who are going to very briefly take you through a case study each of some of the work that we've been doing. So if I could ask Maddie and Alice to join me, please.
Hi there.
All right, I'll just move it over there for you.
So we recently carried out a lease renewal. It was of a light industrial unit warehouse, around 9,000 square foot, and it was located in an established industrial estate of Broomhill, around the southeast area of Bristol. The property was subject to a business tenancy which expired in August 2012, with a passing rent of around £3.50 per square foot. This lease was inside the Act, which meant that the tenant had been holding over for around 9 years, which required a Section 25 to be issued from the landlord to initiate a new lease. The unit was of basic low quality with low minimum eaves heights, but it did have a large external yard for parking and storage compared to the surrounding occupiers. We found quite a lot of local evidence in the surrounding estate that supported an increase to around £4.50 per square foot, and this gave us an increased rent up to £42,000 per annum. We went ahead and agreed this with the landlord and sent across a new heads of terms.
So we recently completed lease renewals on 3 units at Bell Park, a busy industrial estate in Plympton. The units were let to one tenant, but due to being spaced out across the site, each unit had its own lease in place. Because of this, we considered the market rent of each unit individually, primarily utilising other recent lettings on the estate as comparable evidence. We instructed our client solicitor to serve 3 Section 25 notices, offering the tenant 3 new leases and setting out our proposed new rent and terms in each case. We then negotiated with the tenant and came to an agreement on a slightly discounted rent, which reflected the fact that they occupied a large proportion of the estate. We then prepared heads of terms and distributed these to all parties, and a lease was then drawn up by the solicitors.
Touch on business rates mitigation. Obviously, as a landlord, if your tenant leaves and you have a vacant property, this can form quite a big concern for you. So I can see Christy has already joined me. Christy's going to take you through briefly on some of the work that we do in business rates mitigation. Thank you, Christy.
Cool. Thank you, Amy. So whilst lease renewals have been the main topic of conversation in this webinar, business rates can constitute a significant liability for landlords if a lease is not renewed and the property becomes vacant. Properties are granted 3 months relief from business rates when they first become empty, with industrial properties benefiting from 6 months relief. However, once this period has elapsed, the landlord becomes liable for the full amount. Occupation of a property must be 3 things to be classed as rateable occupation. Number 1, actual occupation, physically in or on the property. 2, beneficial occupation, the tenant gets something out of being there. And 3, for a period of at least 6 weeks. A temporary occupation of a property, providing it satisfies these three requirements, can often reset the empty relief for a property, keeping costs down for a landlord whilst a reletting or sale is taking place. If a property is undergoing extensive refurbishment and incapable of beneficial occupation, we may be able to help you reduce your rates liability throughout the period of intrusive construction works. In order to reduce the liability, a check must be submitted through the check challenge appeal process. The process must start at the earliest opportunity when intrusive works start and the property is no longer capable of beneficial occupation. The check must be submitted within the construction or renovation period. An example of the above works can be seen where we were instructed to act on behalf of a local client who had recently acquired a doctor's surgery with the intention to use the unit as a funeral parlour. This change of use required substantial internal works to provide the funeral parlour facilities, during which time they would be liable to pay 100% of the business rates liability. On the commencement of redevelopment works, we submitted an application with supporting evidence to the VOA, with the aim of reducing the rateable value to 0 throughout the period of works. Our check submission was successful, saving our client £3,000 over the 5-month programme of works.
Thank you. Okay, that brings us to the end of the presentation part of today. So if Chris and Jordan could pop back on, and yeah, we can open the floor to some questions or further discussion.
Yeah, thanks to everyone who's spoken and given you some thoughts, and hopefully that's provoked a few questions in people's minds. I'm particularly interested in views on whether you're seeing this increase in Section 26 notices, which the little poll would tend to suggest is the case. So if anyone's got a question, we'd be happy to take it. I don't know whether everyone's been seeing these reversionary leases, but they are quite an intriguing development. I think, Amy, you're going to see some of those come through. It's quite a good way of diffusing the difficulty of tenants wanting to bargain on the rent and getting at least that part secure before you can then deal with that more contentious issue down the line. So I don't know whether anybody out there has seen that.
Yeah, I've definitely seen that so far with a very big retail property, national retailer. And yeah, it can seem slightly daunting for a landlord having a downward rent review, but actually having that commitment to sign up for however many new years it is much better than having it vacant for a while and not achieving that higher rent anyway. So yeah, definitely think.
We've had a question asking whether we expect there'll be any further changes in the lease advisory landlord tenant market in the next few years. It's going to be a period of turmoil, I think, for a little while, particularly in the retail and office markets. We've also got to get to grips with the change to use classes, which I think brings forward some interesting questions. The old story in the past of premium values for some uses may well see disappear. I don't know whether you'd have any thoughts on that, Jordan. Amy, would you like to comment at all? Okay.
I think, yeah, sorry. I think that the lease length is definitely a big one with changes. And I think, as we've been saying, actually keeping on top of these things rather than letting them hold over for a while is it's got to be quite an important sort of takeaway, I think.
Okay. It was mentioned during the presentation about compensation if the landlord doesn't want to grant a new lease, and the question's been asked, what compensation are they required to pay? Actually, Jordan's reading on this.
Sorry, I don't know what happened with my Wi-Fi. Yes, there is compensation that is payable for grounds E to G, and it depends on the rateable value of the property, actually. So that is a very important reason, tying in with business rates, to make sure that the rateable value is correct. So it can be 1 or 2 times the rateable value, depending on the length of occupancy.
Okay, and what it occupies, so it's up to 14 years, isn't it?
Up to 14 years, yeah.
So if you
1 time over 2 times.
Yeah. So if your tenant's been there quite a long time and it's a substantial property, it can add up and mount up. I've seen cases over the years of 6-figure compensation, which clearly becomes quite an issue, and something that has to be factored in to any plans the landlord might have for the next use of the property. Any other questions? Quite happy to share our thoughts.
Nobody is terrified of their upcoming lease renewals from the poll. So
yes,
that was good to
see. and clearly on the radar of a few people. This is going to become more and more the major issue in what lease advisory does. I guess at the beginning of my career, you do 10 rent reviews to 1 lease renewal, and now it's probably weighted more lease renewals than rent reviews. So it's something that landlords have got to get a grip on. And I think if I were to leave one nugget, it's the preparation, and it's identify those circumstances and be ready to act. The horror stories come where they slip past the day, particularly outside the act.
I agree. I think, sorry, Chris, when I dropped out, you asked about the further changes in the L&T market. I do just agree. I think the lease lengths will be going down, and a slightly more aggressive stance from tenants, as you said. I have a current example where it's potentially sort of skipped out the notice stage, it would seem, and the tenants made an application to court before progressing negotiations with the landlord. So the landlord's instructed us to help with that, but that's the most aggressive stance I've seen thus far.
Yeah,
so I imagine that will be on the changing landscape.
That also, thank you, Jordan, is a good example of leaving things far too late.
Yeah.
Needed to get a grip on that situation. But so that's what we wanted to talk to you about today. Hopefully we've provoked a bit of thought, and we're here to help at any time if you'd like to talk to us. We'll also look forward to talking to you again in the future, and if anyone had a particular thought on a topic they'd like to hear discussed, we'd be very grateful to hear and be quite happy to put our thoughts together for you. So hopefully that's been enjoyable. Thank you to all the speakers. You can get our contact details readily from our website. So if you want to talk about any specific issues, more than happy to do that. But to round up, just thank you very much for attending. And we hope that you've had an enjoyable part of the morning. Thank you.
Thank you, Chris. Yeah, and just to say that on the handout section on the top right, we've got our flyer there available to download. That also has our details on there and just summarises, what we can do for you. So yeah, please click on that if you're interested.
Okay, thank you.
Thank you.
Thanks very much.